Morning, everyone. Thank you very much for joining. We have a webinar today on the Mental Capacity Act minefield, which is a nice bit of alliteration there to start the morning. But really what we're looking at is unlocking investment opportunities for deputies and attorneys. My name is James Ward. I head up the private client department at Kingsley Napley law firm. And within the team, we have a very large and well-respected court of protection department, as well as dealing with kind of non-court protection work surrounding lasting powers of attorney. So dealing both with deputies and attorneys. And we are looking at ways in which to help financial advisors, lay deputies and attorneys understanding investments better. We are hosting this webinar with Stella, who are specialists in investing in business relief assets. Matthew Steiner is representing them today, and he'll be able to give you more information about that later in the webinar. If we can go on to the next slide, please. Oh, there we are. Goodness, Matthew, you've got more hair, I think, in that picture, and a beard now. You may not even recognize him, actually, since that. And I look a lot older than that one. But Gemma, you look great, so that's fantastic. Right, next slide, please. So before I get onto the agenda, I just want to kind of set out why we're doing this joint webinar. Matthew and I have been talking for a while now about inheritance tax mitigation. His firm provides a lot of support for financial advisors and clients in terms of mitigating inheritance tax through investments. And one area that cropped up, which is of interest to both of us, was why can't we look to be a little bit more forthright in saving elderly clients inheritance tax when they are effectively having their lives managed by either a deputy or an attorney. And we'll come on to what the difference between deputy and attorney is, etc. But fundamentally, quite often a deputy or an attorney is working with a client who's of an age, say in their 70s, 80s or 90s. And plenty of these clients, certainly within our firm, have well over the inheritance tax threshold. But traditionally, financial advisors have been wary about investing into assets that would, after 2 years, trigger a zero inheritance tax charge if they were to die owning those assets. So with that in mind, Matthew and I, and indeed Gemma, who is a senior associate in the Court of Protection team, got talking about how maybe we can assist attorneys and deputies in their investing criteria. And it's not quite as simple as just simply saying, let's look at investing in loads of business relief assets, however good they are, and however much tax is going to be saved. And we'll be setting that out throughout this webinar. But the agenda is very much in front. I don't need to necessarily read it out, but what is important is it will cover this. It will show the difficulties that are faced by deputies and attorneys. It will show how both Kingsley Napley and Stella can assist attorneys and deputies, especially lay attorneys and deputies, which exist throughout the UK. I understand that we're speaking mainly, I think that's right, Matthew, isn't it, financial advisors who are on this call, but clearly you are the conduit between the client, the attorney or the deputy, and indeed Stella, who will be looking to make the investment. So you're very much key to helping unlock investment opportunities for deputies and attorneys. Next slide, please. So the issues that we're going to be looking at today, and you'll be pleased to know this is my last slide until the end, and far more knowledgeable people will come on after this. But effectively, we're going to be looking at how attorneys and deputies can invest on behalf of P. Now, P is patient. It's not a very glamorous name, but effectively it's the person who is subject to the deputyship order. So say the elderly individual, in this case, who may have no capacity. And the court names them P. The attorneys, where maybe the court isn't involved, often just call it the donor. So if you're similar to the donor, if you're familiar with that phrase. it is important to understand as financial advisors, this can be a very lucrative market, but the attorneys and deputies cannot do whatever they like. They don't have quite the same freedom as a person with full capacity. So that's a very important aspect of this talk. But it doesn't mean that they don't require inheritance tax and financial planning. But in my experience, I think probably in Matthew's experience as well, financial advisors have been a bit nervous in this area. That is why a very good number of you have tuned in today. But I will leave you that whatever is done has to always be done in the best interests of P or the donor. That's really a key totem pole or tent pole or whatever kind of analogy of the Mental Capacity Act 2005. And Gemma will be identifying this in a little bit more detail. And on that note, I'm going to hand over to her so she can get into more detail and run you through with Matthew. You will see me at the end briefly, but thankfully not for too long. Okay, many thanks.
Thank you, James. Thank you, James.
No problems.
Can you hear me? Great. Okay.
Yeah.
So I've summarised the key differences here between deputies and attorneys. Deputies are appointed by the Court of Protection after a person has lost capacity to make their own decisions. When we talk about capacity, there is a legal test for that, and in an application for a deputyship, medical evidence must be provided that shows that a person is not able to make particular decisions for themselves. Capacity is decision specific, so a person may be able to decide that, for instance, that they would like a cup of tea, but actually they're not able to make more serious, important decisions, such as those regarding their finances. The test for capacity is that a person at the relevant time, due to an impairment of the mind, such as dementia, is unable to make a decision because they are unable to understand information relevant to the decision. They're unable to weigh up the pros and cons of the decision. They are unable to retain information relevant to a decision, and they're unable to communicate their decision. So if they're unable to do one of those things, then they will be deemed to lack capacity in the relevant area. The key difference between a deputyship and appointeeship is that, an attorneyship, is that an attorney is appointed by the person themselves when they do have capacity. Another key difference is that deputies are very closely and stringently supervised by the Office of the Public Guardian. When a person executes a lasting power of attorney, the documents are sent to the Office of the Public Guardian, but they have very limited involvement after that. The document will be registered and they will oversee the attorney, but they really won't have any involvement unless a complaint is made or some kind of investigation is necessary, or indeed the attorney approaches them with a question. With deputies, they're required to report annually. And this is very important. They need to provide accounts, and they have to show that they have consulted relevant people when making any kind of decision on behalf of P. They need to show that they've made those decisions based on appropriate advice, and this obviously includes investments. As James mentioned, deputies and attorneys cannot simply take any decision that they wish. They must be sure that they have authority to do so, and that they have made that decision in P's best interests. As you can see on the slide, attorneys will not have authority to delegate decisions to a financial advisor unless that is specifically referenced in the lasting power of attorney document. This is an issue that we are repeatedly seeing come up, and something that we can assist with. Often deputies are not permitted to purchase or sell property, and neither deputies nor attorneys can execute a will. They're also not able to make substantial gifts on behalf of P without approval from the Court of Protection. Next slide, please. As James has mentioned, there are both professional and lay deputies and attorneys. And although we feel that this service may be more of assistance to lay attorneys and deputies, it's worth just pointing out the differences between the two. So with a professional, you'll find that they are permitted to charge P for the services that they're providing. With a deputy, they'll either be charging a fixed fee or they'll be submitting their fees on an annual basis to the Senior Courts Cost Office for approval of their reasonable fees. And they will obviously have many clients who lack capacity in many different situations, but they'll, because of that, will have a lot of experience in assisting people with significant care needs and also significant finances. However, both professional and lay deputies and attorneys are likely to require financial advice, particularly where a person has a variety of assets and, as mentioned, increasing care needs. Professionals are likely to have more experience, so they're going to be aware of the markets, the level of risks that they expect to take, the type of investment vehicles available, and they'll also be more aware of tax planning. However, just because they have that experience doesn't necessarily mean that they're not going to want to delegate that to a financial advisor who has that expert knowledge. Cash flow forecasting is a really helpful tool for both professional and lay deputies and attorneys, as this can indicate the long-term financial needs. Next slide, please. Thank you. One of the things we're often asked is, how should a deputy make decisions? We've talked about best interests. So here is the actual breakdown of what we mean when we say best interests. This is defined in Section 4 of the Mental Capacity Act, as it sets out a list of factors to be considered. So this requires consideration of the person's wishes and feelings, as well as their past views and beliefs. So when they had capacity, what kind of decisions would they have been making? They must also, the attorney or deputy must also discuss the decision with others, such as family, friends and carers, and consider their views, and consider all the relevant circumstances. Crucially, they must invest for the person's benefit and not for their own. Next slide, please. As I've said, they must invest for the person's benefit. So an important way of showing that they've done that is keeping their own money separate from P's. This will avoid mistakes and any confusion, particularly with the Office of the Public Guardian. They take a very stern view where money is mixed in any way. Attorneys and deputies must not take advantage of their position. There's some famous case law existing, which is a case of Buckley, where an attorney used P's money to invest in their own business venture. This is not permitted, and it's very important that attorneys and deputies don't take advantage of their position or let their personal interests conflict with their duties. They're able to receive gifts where this is permitted by the Mental Capacity Act, but where significant gifts are going to be made, then it's necessary to make an application to the Court of Protection. I've said at the bottom here that they must not allow someone else or a financial advisor to decide something that they should. That means they can't delegate unless it's been authorised. We often see in deputyship orders, there is a specific provision made allowing the deputy to delegate to an investment advisor. However, as I said, it's quite common for this not to be in an LPA document. This is a document that people can download from the internet and complete themselves without the assistance of a solicitor. So that is something that can be overlooked. Next slide, please. Other considerations that attorneys and deputies need to consider. As I said before, a lot of issues can arise in the course of a deputyship or attorneyship, and these are some of the reasons. So tax planning is really important, particularly with elderly clients, but the Court of Protection will need to see evidence that it's necessary and the reasons for it. They'll not, if for example, you are wishing to, an attorney or deputy is wishing to make a financial gift, the court simply isn't going to allow that just because of tax planning. It has to be shown that it's in the person's best interest, as I've mentioned before. So perhaps this is something that there was a history of them doing in the past, or that they'd indicated that they would do. Another issue is care. As we all know, care costs are increasing exponentially, and local authorities have now placed very stringent measures. So if a person would perhaps give away their assets to avoid paying for care in the future so that the local authority will then cover it, this would not be allowed. This is called a deprivation of assets. And as I've said, there's very stringent measures in place to prevent this. Other factors that need to be considered include wills. A person may not have had time to execute a will, or their circumstances may have changed, which in effect change their will. So attorneys and deputies can't do this themselves. They would need to apply to the Court of Protection to execute what's known as a statutory will. As I said before, deputies are required to report annually. However, if the Office of the Public Guardian investigates an attorney, they're going to need to see accounts for the time that the attorney has been in their role. Good record keeping is therefore required, and we would recommend this. It goes without saying that any action that's considered fraudulent will be dealt in very strict terms. So as I've mentioned, mixing of money or making a decision that's not in the person's best interests or is a conflict of interest will be dealt with very seriously. Next slide, please. No two cases that we deal with are alike, but we've tried to generalize some of the circumstances of a client as far as possible, just to demonstrate the kind of assistance that we could provide alongside Stella. So we have a case study here of Mrs. P. She's 81 years old and she has 2 children. She's recently downsized her property and it's due to be sold for over 3 million. She's got pension and benefits worth 48 grand per year, and she's been diagnosed with dementia. Prior to her loss of capacity, she's executed a lasting power of attorney for property and affairs in favour of the 2 children, but they did it, as I said, on the internet without the assistance of James or another solicitor, and so they've not included that authority to delegate to a financial advisor. This means that any investment that they would make, the 2 children, they would have to do so, they would have to instruct the financial advisor on an advisory basis rather than a discretionary one. Mrs. P requires care. The current cost is £24,000 per annum, but she has a deteriorating condition. She may need to go into a care home. Her care costs are likely to increase significantly. So some planning is really required here. As I say, she's now deemed to lack capacity to make decisions. Next slide, please. Thank you. How Kingsley Napley could assist. If these attorneys came to our office and asked us how we could assist them, what we would generally do is first take a look at that lasting power of attorney document, and we can advise them what they can and can't do based on the instructions that Mrs. P has given to them. We can also advise them on their legal obligations. So, as I mentioned, how they make decisions in Mrs. P's best interests. An important factor here is the sale of the property. Say, for example, one of the children wanted to buy the property off Mrs. P, but maybe for less than market value, or one of the children wanted to sell the property and the other didn't. This is a kind of situation where an application to the Court of Protection would be necessary because the attorneys aren't agreeing, or because the decision may not necessarily be in Mrs. P's best interests. It's always important to defer to the court at the right time, and legal advice is needed to know when that time is. As I mentioned, there was no authority to delegate to a financial advisor. So we could assist the two attorneys in making that application to the Court of Protection. It's a pretty simple process. However, at the moment, there are long delays with the court, so it's something that we would encourage them to do urgently. We can also advise them on Mrs. P's will, whether she needs, in fact, to make a new one. Then we could advise them on making an application to the court for permission to execute a statutory will. And we could also advise them on any gifts that they may want to make, maybe some financial gifts to their own children. Then we can assist them with that. Next slide, please. Given that Mrs. P now has substantial assets following the sale of her property and the ongoing care costs, then it's very likely that they're going to need financial advice. The Office of the Public Guardian has prepared very detailed guidance on investing as an attorney or deputy, and there's a helpful list here that says what they should do or when they should appoint a financial advisor. So here are some of the circumstances when they should do that. Next slide, please. Even if Mrs. P had not appointed attorneys, she would need a deputy to be appointed to deal with the amount of money that she has. An application would need to be made to the Court of Protection, and authority would need to be granted to a deputy to make decisions about her property and affairs, including the sale of the property. I think even a deputy would want to delegate to a financial advisor in Mrs. P's situation. The kind of other issues that they're going to need to concentrate on for Mrs. P, such as her care costs, her bills she may need to pay, adaptations to her property, they're really going to want to concentrate on those and delegate to a financial advisor. So I think in most circumstances, it's going to be appropriate. Next slide, please. Next slide, please. I'm now going to hand over to Matthew, who will introduce you to Stella and the service that they may be able to provide in this scenario. Thank you. Sorry, Matthew, you're on mute.
Is that better? Yeah, great. Thanks very much, Gemma. Would you mind moving the slide on for me, please, Mel? Well, good morning, everybody. Thank you very much for joining us today. My name is Matthew Steiner. I'm the Corporate Director at Stella Asset Management. And alongside the team at Kingsley Napley, I'm delighted really to be able to bring you this new service, which has been some months in the making, which we believe can help to service the needs of deputies and attorneys. Before we come to that though, I'm just going to focus on some of the tax planning strategies that are available from Stella, which utilise the business relief legislation. The previous slide you saw a minute ago had our regulatory notices on it, and really they are saying that Stella Asset Management Limited is regulated and authorised by the Financial Conduct Authority, and does not offer investment or tax advice or comment on suitability. Next slide, please. So Stella is an award-winning provider of inheritance tax services. Our directors have over 30 years experience in designing and managing tax efficient services for those of your clients seeking to leave a lasting legacy. As a specialist in this area, we have been working with financial advisors like you and other private client professionals to promote and develop a collaborative approach to estate and intergenerational tax planning. Our services are ideal for those clients who wish to retain control of their capital throughout their lifetime, and they also support intergenerational planning. So as a financial advisor, you can recommend everything from a simple discretionary managed ITS portfolio to a bespoke tailored trading company, which gives you the freedom to agree with your client which assets they hold. On the listed side, we've been running AIM portfolios for nearly 13 years now, and last year we recruited an award-winning fund manager or portfolio manager called Stephen English to take over the management of our AIM strategy. Next slide, please. So I just thought I'd start off with a little reminder about business relief. Business relief was actually formerly called business property relief, and it's been legislation that's been around for quite some time now, originally introduced in the 1976 Finance Act, and has really remained largely unchanged since that date. Assets that qualify, or qualifying activities or qualifying assets, provide 100% relief from inheritance tax after 2 years, and therefore have a nil value for IHT in the estate of the deceased. As there is no transfer of capital or ownership, these services can be widely used in planning for attorneys and deputies, providing the correct investment permissions are in place. And you heard all about that from Gemma just now. Next slide, please. So as I say, we specialise really in business relief and services that qualify for those things, that relief. And we actually offer a wide range of qualifying business activities, which include forestry, golf, hotel management, property development, to name but a few. I think we've probably got one of the largest range of services or business activities in the marketplace. And this choice and diversity provides us with flexibility in how we can manage those assets on behalf of our investors, and allows us to asset allocate, which has proved to be invaluable over recent months with the pandemic. Investors access these business activities through our IHT services, which you can see on the screen here, and these have been carefully designed to cater for the needs of individuals and their families. And we can also work with business owners, trustees, and obviously with deputies and attorneys. And we believe this helps planners to effectively support their clients, as IHT efficiency can be achieved in just 2 years. Next slide. In addition to all of that, we've learned a lot about the complexity, I think, of inheritance tax, estate planning, succession planning. And we know that advising clients on intergenerational estate planning matters can be very complicated. And the planning often requires collaboration between financial advisors and other professionals such as Kingsley Napley. So to assist with this, we've been running now for some time the Stellar Partner Services, which brings together this professional expertise. It comprises a comprehensive range of services that you can call upon from experienced estate planning specialists like Kingsley Napley, but also names like Zedra and Westbridge Tax, but there's many more. So do take some time and have a look at the contacts and connections that you can make through that service. Next slide, please, Mel. So if we cast our mind back to Mrs. P in Gemma's case study, following their consultation with Kingsley Napley, the attorney made an application to obtain the appropriate investment powers, and once these had been granted, the financial advisor recommended the Stellar ITS, which is one of our, I suppose, more basic services. As part of the application, and Gemma can speak more about this, it was necessary to demonstrate the rationale behind the proposed investments, and the advisor recommended that this particular service because the service was designed, or is designed, to mitigate IHT liability after 2 years. It could provide security and a modest capital growth. Mrs. P retains control of her capital for the rest of her life. So if her circumstances were to change, that money would still be available to her. And it could form part of a strategy to create a tax-efficient legacy for her beneficiaries. So really it met all the requirements that the court was looking for. Next slide. Now, many of you, financial advisors specifically, will be familiar with the ITS as a concept in the marketplace. And in essence, really, ours is no different to others in the space, other than we have greater diversification. And you'll see in a couple of slides, we've got 7 business activities that clients automatically participate in. So it's far more diversified than most of our competitors. With the exception of bridging which is a lending type exercise, all of those business activities are backed by land or property. So there's lots of capital security, which was important in the case of Mrs. P. And we actually have a target return, a range of target returns between 3 and 4.5%. So again, that's higher than the general standard return on ITSs, and that was important in this case as well. Next slide. Thank you. So our range of services provide choice and flexibility when planning. Oh, sorry, excuse me, I'm on the wrong slide now. So the structure for an ITS is very similar. Again, you'll be familiar with this. Once the attorney made the application form, shares get issued and capital gets deployed into the underlying IHT companies. As soon as Mrs. P receives those shares, the 2-year clock starts from an IHT perspective. So it's quite a quick solution to removing capital from your, or to removing value from your estate. The shares are held, like always, in a discretionary portfolio, and then the share capital gets allocated to the underlying business activities. So the client ends up with a diversified portfolio of those asset-backed things like forestry, farming, etc. Next slide, please. You can see currently the activities that are on offer to new investors are hotels, bridging finance, commercial forestry. We're very big on commercial and residential development at Stella. We've got lots of different projects all over the country there. We've also recently, in the last 2 or 3 years, moved into golf courses and care homes, both of which have performed very well through lockdown, which has been very good. And for those of you that have known us for longer, we've got a very, very long and successful pedigree in managing and exiting from commercial forestry plantations. So they're your Scottish Sitka spruce plantations that you may have seen if you've been to any of our webinars before, or if you've been to Scotland. Next slide, please. So very simply, I mean, the beauty of the ITS is a very simple concept here. So once the money was deployed, once the money was invested into the service, it sits there, it grows at between 3 and 4.5% per annum. All the activities that we select for this service are going to be business relief qualifying. So there is no, we don't want to take any kind of regulatory risk whatsoever here. It's a pure BR play, and therefore 100% of the value and the future value, providing it's held at the time the client passes, would qualify for the relief at 100%. Next slide. Yeah, next slide. Great. So in the case of Mrs. P, it was a very simple and straightforward solution for her. We've obviously got a greater range of services that offer clients more flexibility and actually greater choice as well. And I've just put down here a few ideas to show the breadth of planning opportunities really that business relief can offer. If I go back to my days when I worked for a merchant bank in the early part of 2000, business relief was always like a deathbed planning exercise. And I think with all the restrictions now that have been placed on tax advantage services and products, people have really woken up to the breadth of planning ideas that business relief offers. So as you can see here, you've got your elderly clients who need short-term solutions to IHT, but it also works for younger clients who've got surplus capital, where they don't have that many options for sheltering their capital in other tax vehicles. There's opportunities for interplay with BR and trust planning. There's opportunities to obviously use your ISA transfers, APS transfers. There's a lot of things you can do with business owners, and that's in terms of the wholly and mainly rules and regulations, and with family offices, in addition to the things that attorneys and deputies can do. So there's an awful lot of things and applications for it. We're obviously focusing today on the deputies and attorney market, but if you do have any questions about any of the things that we can offer, please do get in touch. Next slide, please. So we come at last to the reason that we are here, which is to launch a new review service for deputies and attorneys. Over the last few months, as you heard from James at the beginning, Stella and Kingsley Napley have been working closely together to develop this service, which will provide support and reassurance to deputies and attorneys who want to plan on behalf of their loved ones. And as you heard again from James, this is a part of the market that we think is quite underserved at the moment. Next slide. The service will focus on 4 main categories, which are attorneys, deputies, both professional and lay, and trustees or trusts. And amongst other investment options will be the use of Stella IHT services to provide mitigation from inheritance tax. So I think at this point, Gemma, I'm going to hand back to you just so you can provide a high-level overview of each of the 4 options.
Thank you, Matthew. Next slide, please. Thank you. As you can see here, we can offer assistance to attorneys. This is all set out in the brochure that you'll find on our webpage. But as I mentioned with Mrs. P, what we can do is look at that LPA document and advise the attorneys as to what their legal obligations, what kind of decisions they are and are not able to make, and we can support them in any applications that they may need to make to the Court of Protection for further authority. Next slide, please. Thank you. For professional deputies, we ourselves here at Kingsley Napley do act as professional deputy for a number of clients in a range of different circumstances. We can apply for that authority to act as deputy and work with the family in making any decisions in the person's best interests. We'll also then consider requesting investment proposals from a range of financial advisors or through Stella. Next slide, please. We can also assist lay deputies. So again, we can assist them in understanding their legal obligations as a deputy to P, but we can also in fact assist them in making their application to the Court of Protection for that authority. We can advise them on the specific types of authority that they may require. So things like authority to purchase or sell a house or property, deal with a business, make gifts, or even execute a statutory will, as I mentioned before. Again, we can also introduce the deputy to the obligations that they have in terms of investment and give them general advice as to the kind of direction that they may need to go in through introductions to financial advisors. Next slide, please. We can also assist with clients who have received a personal injury or clinical negligence award. In order to ring fence their funds from benefits and care funding, it means that those funds will not be included in the calculation of their assets for those benefits. Then we can assist them in setting up a personal injury trust. They may have a professional trustee or they may act as lay trustees themselves, but we can assist with both of those circumstances. The duties of trustees is actually quite similar to that of a attorney or deputy, so we can provide ongoing advice as to their obligations and again advice in terms of what they may or may not want to do in terms of investments. Next slide, please.
Yeah, so I think, Gemma, really it's an opportunity, isn't it, for financial advisors to go back maybe and review client cases where they haven't acted up till now for whatever reason, because they've not felt maybe comfortable, or perhaps where advice has gone in to double check that the attorneyship or the trust document has the right permissions in it. So it's really an opportunity for everybody to go back and revisit clients, maybe reach out to new clients that you're aware of where you haven't been giving advice with the opportunity now of helping there. Would you agree?
Yes, absolutely. The purpose of this service is to provide confidence and reassurance to financial advisors who have clients who are deputies or attorneys.
Yeah.
So as we said, if you do have any clients or you have anybody that you can think of that may need some advice, then please do get in touch. We'll be holding a clinic further to this webinar on the 7th of October, so you can have a no obligation confidential discussion with us, and we can talk you through the circumstances and give you any pointers. So the next slide, please. We're going to take some questions now. We've had a few in the chat. James, shall I refer to you?
I'm back. We've had lots of questions, so thank you all for tuning in, and thank you, Matthew and Gemma, for being so clear and succinct about how we can help and the issues that need help. Certainly, as I mentioned earlier, talking to financial advisors like yourself, and there's lots on the call. You are the kind of gatekeepers to these clients, they're effectively trusting you to provide them with the best information at the best time, to make the best investments, to save the best amount of tax. We're really facilitators at either end of the market, Stella and Kingsley Napoli. So a lot of the driving force is within your hands. We have lots of questions, actually. The easiest one is it possible to get a copy of the slides? Yeah, I'm sure. And then the rest I'll hand over to Matthew. No, no. I mean, fundamentally, we've got some very interesting ones at the beginning from Matthew Wright. A couple of questions there, which I think, Gemma, you were going to be able to have a stab at. Can everyone see the questions? Is that right? Just to double check.
Yeah. So shall I just read the first one out? Because I've just got the first questions from somebody anonymous that says, do the same requirements to have appropriate powers to delegate for investments apply to EPAs as well? There appear to be different views across different DFM providers. All I'd say, I'll let Gemma answer the EPA point, is that when advisors phone providers like Stella, we are not qualified to give answers to things like that. And it can be very difficult because people might go to another provider and get an answer they want and then act on that decision, when really you can't. I don't think you can rely upon that. And that's really one of the reasons we started developing relationships with firms like Kingsley Napoli, because we wanted the people that come to Stella to be confident about the decision they're making with the appropriate advice from someone that's able to give it. So in addition to Kingsley Napoli, we've got tax and trustee professionals that are qualified to answer those types of questions, just to ensure the advice is correct. Gemma, can I pass you the EPA point?
Yeah, absolutely. Thanks, Matthew. So as I mentioned during my talk, there is specific guidance from the Office of the Public Guardian called Investing for Someone as Their Attorney or Deputy. And I can put a link to this in the chat, but in the very last sentence, it says, do not allow someone else or a financial advisor to decide something that you should, unless it's been authorized by the person in the LPA, EPA, or the court. So the same situation applies with EPAs and LPAs.
Thank you, Gemma. That would be useful. Sorry, there were the two first questions, which I kind of answered, just saying we'd answer them at the end. On the answers section, Matthew. So, and it's another Matthew, fellow Matthew Wright, with two questions coming in, and Gemma was going to answer those two. If you can turn to those.
The answers section.
Yeah. So the first question is about personal injury and clinical negligence awards. So that the situation where somebody's received a significant award due to the nature of the award, which includes covering the cost of future care. Am I still correct in saying that for these clients, BPR portfolios or indeed any IHT planning should not be undertaken, as this will deprive P of capital? So the answer really is it depends on the circumstances. I mean, the case law on specifically clinical negligence awards says that the last pound should be spent on the last breath. So this is the case of RE-A. So really, in that kind of situation, it may not be appropriate. However, each case is person specific. If you have a person that receives an award later on in their life, then as part of that best interest checklist, you need to look at what they may have done prior to the loss of capacity or the injury. And although the court is very wary of IHT planning, there is case law re JMA where gifting of 7 million for tax reasons was allowed. So as I say, it's case specific. I mentioned before about cash flow modelling. If you can show that, you know, a person's assets are being invested in a way that they will last beyond their lifetime, then you know, you might be in a situation where you can justify this. But I think the key is to look at each case on its own circumstances and think about that best interest checklist.
And I mean, on that, Gemma, you know, we obviously have a lot of very young people who sadly have been given awards, and clearly inheritance tax planning around them may not be appropriate. So we are trying to focus slightly on the elderly market here. But there is, you know, as everyone's only too aware, there's some big differences between gifting as opposed to investing in a way that mitigates tax. Because one of the great things about business relief, when done properly, is it can, from my perspective anyway, dealing with a lot of elderly clients, is it mitigates tax, but it means that if they're suddenly there, you know, they can't put food on the table, you know, as long as there's liquidity in the investment, they can get the cash back. You know, one of my biggest concerns with clients, and the things I always ask them, this is the ones that do have capacity, is can you afford to give it away? You know, there's no point in giving away assets and then going cap in hand to your children at a later date. So, you know, business relief does have that happy medium just for standard clients. So we push that on to clients who have, you know, elderly. Yes, they may have got an award through the personal injury or clin neg side of it, or they may just be having their own wealth. But at least it means they've still got those assets. So as an attorney or a deputy, you don't feel like you're depriving them of that. So if that 7 million gift had been, instead of gifted, Gemma, had been invested in business relief, the same principle would have happened, that you would ideally think that 40% would have been saved, but that 7 million would still have been available. The issue is that the children can't pay off their mortgage and they can't send their kids to private school if there isn't the gift made. That's the family dynamic that needs to be considered. Anyway, sorry, Gemma, there's one other one from Matthew, I think.
Well, you got the on the answered one, you got the same one about the court of protection there, just that's underneath. Right. Yeah, let's do that one.
So when would the Court of Protection stipulate that professional deputy should be appointed rather than a lay deputy? Is that based on asset base, size or capability of immediate family? I think the understanding I have from the Court of Protection is that they're not really going to stipulate. They actually, in my experience, prefer to have family members taking that role. I think what we find is that where there is a clinical negligence or personal injury award from the High Court, it's the High Court that insists that a professional deputy is appointed. So as long as the person is over 18 and satisfies the suitability criteria, so they don't have a criminal record, no CCJs, no bankruptcy, then I don't think there is any particular stipulation from the Court of Protection. What I would say, though, is that if there is a dispute within the family members, so say perhaps one son makes the application for the deputyship and another son objects to that application, in that kind of situation, the court is not going to want to get involved in a family dispute and will probably automatically revert to either a panel deputy or advising the parties to instruct an independent professional deputy.
Yeah. And Gemma and her team look after around 100 or so deputyships, just a bit more than that. And yes, quite a lot of them stem from the clin neg personal injury side, but more and more coming on the elderly side. And unfortunately, the levels of financial abuse that we're seeing from lay attorneys, which is a lot less kind of strict to get appointed, and also deputies, is very sad to see. And sometimes, if there, as Gemma mentioned, if there is difficulty within the family, then a neutral party is the only option. That's.
And James, can I ask a question about that? Because we've come across this before with other financial advisors. Does the court differentiate between deliberate abuse and accidental abuse? So in other words, the lay trustee did it without knowing what they were doing?
Yes, I mean, deliberate is, deliberate is fraud and it's a criminal offence. It's certainly something. I mean, we have a very well-regarded criminal team and dispute resolution team within Kingsley Napley, and they've been assisting us on some of these issues. I've had to step in and become professional executor or administrator for estates where there has been abuse by powers of attorney, by attorneys, which is the more worrying one from my perspective. So less in Gemmisfield and deputies, more because anyone can name. You can log on to the website, lasting power of attorney website, and without getting the proper advice, you can be drafting a power of attorney that can be naming people, or you can be doing it for your mother. It can all be signed by her, and suddenly it's registered, and before you know it, somebody's able to take advantage of their bank account or property. Now that very deliberate is always going to be seen as a lot worse. I mean, whether it is menswear or I don't know, I've done crime for years. Everyone that I represented got put in prison, so that's not really my area. But I would say that if you're doing something by mistake, then you're not going to be held to the same account. But people should be seeking advice. Advice is out there. And one question that crops up is, will Kingsley Napley provide their service in conjunction with another discretionary fund manager? Well, the reality is that there's law firms and other fund managers that do what we're talking about. Stella and Kingsley Napley are just linking up in the way. There are obviously other providers of financial services and legal services, but I think that what's important is if you're looking at this very specific point, which is really about investing and maybe kind of an asset protection, where we're looking to protect assets from that 40% inheritance tax charge, you need to be getting the right advice from a legal perspective. So people that understand powers of attorney and deputies and their fiduciary duties, and need to be getting the right advice from, as you said, fund manager who's specialising in business relief investment, whether it be EIS, AIM, or some more focused investment like Matthew was talking about. And I mean, Matthew, if I remember rightly, you've got some very interesting kind of charts on your website looking at how performance has done over the years, and so that this is a very specialised area. That's what I can say. Obviously, we don't give financial advice, Kingsley Napley, and neither does Matthew give tax advice or advice on attorneys and deputies. But it's the middle person, generally the people we're speaking to now, who are absolutely crucial, because they are the ones who are speaking to the clients on a regular basis. And if you are speaking to clients, it's easy enough to direct them to get advice, whether it be to either Matthew, Gemma, myself, or some other specialist in that area. Okay.
Yeah.
I think that's Gary's got one. Yeah.
So to answer Gary's question, which is how are we able to assess the true risk of the underlying funds and what is the liquidity of the scheme? The simplest answer is, Gary, there are 3 or 4 independent research houses that provide research upon inheritance tax services like ours. MyCap and Allenbridge has come out of the market a little bit now, but MyCap probably being the best one. And you can get everything you need from them in terms of how it performs. We also produce our own DDQ as well, which we can let you have. And then there's a couple of new ones at the bottom now. I think Gemma, Anonymous is your one, 1043.
Okay, so this is somebody who is a client and acts as a financial LPA for an aged relative. For first bits for you, Matthew, I assume she would need to appoint an IFA before introducing her to Stella.
Yes, generally the clients come to us with a financial advisor who can advise on the suitability and the appropriateness of the investments they're making. So yes, that's the normal route.
Okay, so turning to, it says that she's resisting the need to appoint an IFA. This is a situation where you need to assess where your aged relative has capacity to refuse to instruct an IFA, and if your belief is that she's not making that decision in accordance with the test I mentioned before, then then you can make that decision if you believe that is in her best interests. You've then gone on to say that the power of attorney appointment does not provide for appointment of an IFA. You would be able to seek advice from an IFA. I think the issue that you would come a cropper would be where if you needed to make that investment, instruct them to and delegate any kind of authority, you'd be having to do so on an advisory basis. So every single asset that you're investing in, you would need to have oversight of, without unless she's able to amend the LPA now, if she has capacity to amend it now. Otherwise, you'd need to make that application to the Court of Protection.
And that's something you could help with, isn't it?
Absolutely, yeah.
Yeah, and just quickly on that point, then if the decision was that the advisor was going to be too difficult, they can come to Stella. We just have to have a lot of information so that they are effectively self-certifying, or you would be self-certifying on behalf of that client, and there's some paperwork to fill in. So it's a slightly arduous process, but it is possible, and that would obviously have to be supported by a certified copy of the power of attorney as well.
Okay, thank you, Matthew. Thank you, Gemma, as well. Just to wrap up, I'm just sending some information about an estate planning summit, and I put that link there, and thank you for uploading that as well. That King's Aptly is part of, along with a number of other different advisors, being hosted by Stella on the 21st of October this year. It is going to cover a huge amount of areas in terms of estate planning and the difficulties with estate planning. I, for one, am on a panel talking about hard questions about estate planning, and Gemma is certainly doing a bit more overview regarding attorneys and deputies. So it's packed with interesting aspects of it, and the information can be found at that web address, with the link of which I posted on the chat. Thank you for so many of you, actually, almost everyone staying until the end. I hope you found this useful. If you've got questions directly about deputies and attorneys, then the best person probably to go in the first instance is Gemma, because and then there's the clinic, I think, that you mentioned. What date was that again, Gemma?
The 7th of October, and there's there'll be a link to follow with an opportunity to book an appointment on that.
Fantastic. Well, thank you very much for all of your time. Enjoy what is a sunny day in between rain, and hopefully you're not spending all your time queuing at petrol stations, like Matthew's probably about to have to. Anyway, very good. All the best, everyone. Bye then.
Thanks ever so much.